So now let's put it together in execution. And this is intended to be kind of just like a checklist, a how-to for you guys. Creating a hook, creating chapters, and then at the end, we're going to put it all together into a coherent story, narrative, argument. So let's create a hook. First, we identify what is the dominant emotion. Why? Why should your side win from the heart, not from the head? Why do you feel? Why should the jury feel like you win? What is the emotional epicenter of the story? What is the most interesting? I should say interesting. Where does that emotion come out in the story? There's going to be one point where it peaks. Identify that. Once you've identified that, go back to our techniques. Use trilogy, storytelling, news headline, quotes from trial, historical quotes. And you need to create a hook that is retainable, recallable, and retellable. Creating chapters. What I suggest to everyone, put a bunch of blank pages at the end of your trial notebook. And say 1 page per argument, right at the top, whatever the argument is. Bad eyewitness ID. So you've got all these in the back of your trial notebook. And as the trial progresses, something may pop up. Maybe a quote from a witness, maybe an idea in your head. You just flip back, just jot it down on that page. And by the time you get to your closing, you've got all your arguments already done for you. Organize later. That's another reason we keep it on separate sheets of paper. Because then at the end, then you can worry about organizing. And I think if you try to organize it up front, you're going to hit writer's block real bad. Oh, should I do this one first? Should I do that one? You're wasting time. Don't worry about it. Get it all out there. The same thing I think is true also for writing. I have this problem when I write, and it's taken me years to realize it. I don't like editing. I want that first sentence to be perfect, and I'll sit there and toil for 20, 30 minutes to write one sentence. And it's only after years and years that I realize the best thing to do is just write everything, put it to the side, come back later, reorganize it, reiterate it the way you want. Organize later, let's get them all out there. Factual arguments, legal arguments, damage arguments, and rebuttal arguments. So on that 1 page piece of paper, you got your argument at the top. Bad eyewitness ID. Create a new hook around that argument. Or link it back to your main hook. What quotes from trial support this argument? Plan on transitions. Clean headlines coming in, clean hooks coming in, and clean exit. On exit, it can be as simple as this. Blah, 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 blah. Now let's talk about the ID in this case. Let's talk about what questions we have about that ID. Or you stop, you pause, maybe use a little bit of movement, go look at your notes, blah, blah, blah. Come back and jump into it. Obviously, plowing directly from one argument to the next is bad for a number of reasons. Not the least of which is if you lost their attention and they were bored toward the end of that one, you're not going to magically regain that attention if you just plow through it. But if you have a good transition, pause, you may be able to recapture their attention. What visual aids and exhibits are you going to use to support this argument? going to be in. What objections do you anticipate? Are you planning on pushing the envelope here with your description of the law? Be prepared. The foreperson rebuttal. What that means, I usually reserve a little chapter toward the end of the chapter, I guess I could say section at the end of the chapter. Again, you're being the reasonable person. You know what the average person is going to probably respond with. So, talking about bad eyewitness ID, blah 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 blah. You get to the end of your of that chapter. Say, now, some of you might be thinking, well, the prosecution has no burden to prove the height of this guy, and just because the witness was mistaken about the height. Who cares? The prosecution doesn't have to prove that. That's not an element of the crime. But let's not forget that tells us how well they were proceeding. The fact that they were wrong about the height of the person, do you think that means that they might be wrong about anything else with the identification? It's this idea of arming the jurors. You're not telling them to go back there and say that. But the jurors who agree with you are going to be hearing those arguments. And then when they hear those arguments behind closed doors, now you've armed your allies to use those arguments. And of course, mindset. Is this chapter oriented around the dominant emotion of the story? Is it empathetic to the jury, to what they're hearing, seeing, remembering, their understanding of the law? And of course, are you on the offensive the whole time here? Are you being the foreperson? Legal arguments. KISS. Keep it simple. Thank you. Now, why separate chapters? I tend to keep the factual arguments factual. I try to keep the law out of those as much as I can. I use separate chapters because I can cue them up and you can give them a headline. Okay, well, let's talk about what the law says now. So they know, okay, all right, here we go. We're going for the law. And also, it gives you the chance to reiterate the arguments you've been making. So bad eyewitness ID, blah, 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 blah. You make all your arguments. You get to the legal arguments. And we talk about, well, the law gives us some factors to consider with eyewitness ID. So let's go through those factors. Blah, 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 blah. Boom. But you've already addressed that. So again, you're just getting another chance to double down on some of the stronger points that you have already made. Again, you're arming your allies. You're equipping the other jurors with the arguments they need to persuade. And of course, rebuttal arguments. You have an idea of what the other side is going to argue. Damage arguments from a criminal defense attorney who has never once in his life argued for damages. Again, keep it simple. You've got basically economic damages. That's going to be things like medical bills, lost wages, non-economic damages. That's going to be stuff like punitive damages, pain and suffering, and anticipate what the rebuttal arguments are going to be. We know we're talking about money, so somebody back there is going to say, do they really need that much? Be prepared for that. Someone may say, do they really need, a new wheelchair ramp for their house? Oh, I think that's ridiculous. Well, be prepared to deal with that. Rebuttal. This is a section in your outline that's blank. This is where you're listening to the other side and you're putting down the arguments on the fly for what they're going to say. And it's important here, again, to have a headline. You know, so you might, what I usually say is something to the effect of, you know, burden of proof, blah, blah, blah. You know, so the prosecutor is going to get a chance to come back up here. They're going to get one last chance to talk to you. And I'm not going to get a chance to respond to them. So I want to take this opportunity to respond to some of the things that they've said. Boom, 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 boom. Set some fires. My final organization view looks like this. Hook, chapters. So now that we've done all that, now you can organize your chapters. Go with the strongest one first. And there's psychology behind this. If you start with your weakest argument first, you might go, and you build up to a stronger argument, that is really going to poison the well as you go up the scale. Whereas if you start with a really strong argument, they're going to be much more accepting of the weaker argument down the line. And attention. Chances are, attention-wise, they're going to get bored farther down here. Their attention is going to be the highest at the beginning. So start strong, because they're going to be paying the most attention. First and last words out of my mouth are always the same thing. It's always my hook. Start with the hook, go through the chapters, talk about the law, rebuttal, do a quick recap, and then the ask. And the ask is just that. What verdict do you want them to come to? I like to take the jury instruction and say, you know, sign here for not guilty. If you have a little trilogy, you know, blah, blah, blah. Sign here for not guilty. You know, we don't know what Dan Jones saw out the window. Sign here for not liable. They'd end with the hook. Summary of execution, create the hook. Create your chapters, and organize. Face it, not guilty, that's how I stay guilty.